Please, your lordship, my lord. Item 17 of today's list, my lord, can be taken up after 4 weeks, my lord, to bring some documents on records. My lord. It will be helpful for the adjudication.
Submits that he is desirous of bringing some documents on record and needs 4 weeks' time to do the needful. Any objection from the other side?
Lordship, I am for the respondent, my lord.
The other side has no objection. List up 4 weeks as planned.
Obliged, my lord.
Lordship, I pray for listing of this writ appeal, which was filed on 27th of June.
May it please, your lordship, I'd like to mention item number 7, lordship.
7, what happened, madam?
Lordship, it has come for orders. It may be fixed for admission, lordship. All the pleadings have been completed.
Let the matter be called out. Wait for a while. Let the matter be called.
Obliged, lordship.
Yes.
May I please, your lordship? With the consent of the other side, lordship, I beg to mention item number 22.
20,
22, lordship.
22. What happened, madam?
Mr. Arkady Chaudhary has certain personal difficulties.
It
today,
is
lordship.
stated that Deputy SGI, Mr. Arkady Chaudhary, is facing some personal difficulty and is not available today. A request is made to adjourn the matter. The other side has no objection. List up to 2 weeks.
Obliged.
May I please, lordship? With the consent of others, I beg to mention item number 19. lordship.
19,
Yes, lordship.
the counsel for the appellant has circulated an adjournment slip. The other side has no objection, does not object to the prayer for adjournment. List of 4 weeks as prayed.
Obliged, lordship. May I please, my lord, I beg to mention item number 20 and 21, my lord.
21, all right. What happened?
My lord, Mr. Esbota is out of station, my lord, so I pray for on next week, my lord. He's out of station.
Counsel for the appellant has circulated an adjournment slip. The other side has no objection to the prayer for adjournment. List up to 3 weeks.
My lord, one more pair, my lord. In item number 26, my lord, lordship, like
26, list before another bench of which
my lord.
Honorable Justice Eddie Chaudhary is not a member. There is one more in the supplementary.
Yes, my lord. 40 and 41, my lord.
40, 41. So, same order.
Highly blessed.
May it please, your lordship. Lordship, I need to mention item 38, my lord. I have
Yes,
taken the consent of the appellant, my lord.
it's an interlocutory application. What is it for?
My
Let
lord,
us see
but I have to file a short reply, my objection. my lord.
to the interlocutory application.
Yes, my lord.
Let the matter be called out. We'll see.
Obliged.
May I please, your lordship? I'd
Yes,
like to
Mr.
mention item number 27, my lord, with the consent of the other side, my lord. Here, my lord, there was some subsequent developments last week, my lord. I want to bring them on record by filing an affidavit, my lord.
Mr. Datta submits that some subsequent developments have taken place during the pendency of the writ appeal and is desirous to bring the same on record. List of 4 weeks as prayed.
May I please, your lord?
My lord.
I beg to mention item 46, it may come after 3 because I got instruction from KVS headquarters that they need some adjournment of this discussion.
46
46.
on council. Mr. Your good name, please.
SC Biswas.
As CBS was appearing for the respondent. Praise for time. List up 4 weeks.
May it please, your lordship, a joint prayer for item number 45, lordship. The matter may not be taken up today, lordship. The matter may be taken up on Tuesday, lordship.
Tuesday.
If it is convenient for the court, lordship.
What is the matter about? It's a
Lordship,
PIL.
yes, lordship.
What is it about?
It's about the causing of flood, the damage caused by the flood in the district of Gulaghar.
Then
Under
it's pending since 2018.
the.
What do you want an adjournment in matter? Let the matter be called out. We'll see.
Senior is out of
Only
state.
for today, lordship, Mr. Mishra, sir, DK Mishra is leading the matter and he has got some personal difficulty, lordship. Only
It's
for.
stated that Mr. TK Mishra, senior advocate representing the response numbers 1 to
1 to
3
3, lordship.
is not available today. Or request is made to adjourn the matter. List of 2 weeks as prayed.
Obliged, lordship.
My lord, with the consent of the other side, Mr. Abdurrabha, I beg to mention item 43. That's
43.
supply.
Hearing matter.
Yes, sir.
All right. MSB Chaudhary appearing representing the appellants. What is the appeal about, petition about?
we have challenged the legality and validity of the Rabha Assam Autonomous Council, Lordship.
Hmm.
So
So this petition is pending since 2015. If you don't have any hope of success, why keep it pending?
may I pray
8
for
years.
the- on 3rd of August, Lordship. My senior will argue this matter.
Place for time. List on 3rd August as right.
May it please your lordship? Your lordship, I beg to mention for listing of a matter, your lordship.
What is it about?
The matter relates to transfer matter, your lordship.
Hmm.
The day when I joined my new place of posting, your lordship, the same day I was being transferred to another place.
Hmm.
And instead of my place,
This is
private.
a writ appeal.
Yes, yes, your lordship.
When was the single bench order passed?
It was. I have to get back to your lordship because it's not.
So you don't even know the date of the single bench order.
It was filed
Yes.
yesterday, your lordship. So
What is the date of the SP order? Let's know. That
I
you
need
have
to
to mention in your requisition, application itself. Then what is the date of the impugned order? How do you plead urgency then?
actually, I'm not supposed to mention your lordship. The council was supposed to
So
mention. his
you
absolute
proxy
date based on-
mentioning. Let the council consent come.
Can it be listed on Friday, your lordship?
Madam,
Some
just
urgency.
tell us what is the date of the impugned order. A simple query we have made.
Can I beg to, can I get back to you tomorrow, your lordship? I'll check. in my-
Tomorrow, all right. Make a
Deeply
mention
obliged,
tomorrow.
your lordship.
My please, your lordship. Lordship, I pray for listing of WPC 10923.
23.
Yes.
What is the next date in the matter, madam?
Actually, as per the last order, it was to be listed tomorrow, but it was not reflected.
Find out if it's not listed, fixed date has to be
Like
listed.
your lordship.
All right.
But I am praying for listing of a writ petition tomorrow, my lord, challenging a certain amendment made by the state to the medical college admission rules of 2017.
Mhm.
Tomorrow, my lord.
When did you file the petition?
Today morning, my lord. The notification was of 17th July, my lord.
Okay, tomorrow.
Public.
Lordship, I pray for listing this writ appeal, which was filed on 27th of June, my lord.
Yes, what is the date of the impugned
Date
order?
of,
sir?
on 13th June, my lord.
13 June. All right, get it listed on Friday.
Right, Lordship. I love this.
Daily list for orders item 1.
Adjournment slip.
On behalf of the secretary, we have filed the affidavit.
You filed already?
Yes, yes. We could file it yesterday.
Yesterday.
Yesterday we have filed.
Affidavit on behalf of the principal secretary. Oh, Secretary Hills Council,
Secretary,
Hills area.
Lordship.
Mr. Nath submits that he has already filed affidavit on behalf of the secretary.
Yeah.
Hills Development Council. Council for the petitioner has circulated an adjournment slip list after 3 weeks. No one is present to represent the petitioner in this case. List after 3 weeks.
Item number 2.
May I please, Lordship?
Yes.
Lordship, in terms of order dated 8/5/2023,
Mm.
this court had taken a view that the disposal of the petitions pending before single bench needs to be awaited.
Mhm.
It is as it is before the single bench, Lordship.
Status continues, same status.
My lord. No stay order is passed. The order in the PIL was that the enclosures will be evicted and they have given an undertaking. Now, my lord, by taking the
If
plea,
there is a order of stay by single bench,
not
that's a
stay,
legal right. There's no stay.
no stay.
There are two cases pending, Lordship. In one case, it has been stayed. In the other, there is no.
All right, the writ petitions pending. Yes, the order is there on record. You have placed the order. Arya Vidyapeeth College.
Lordship.
My lord, repetition may be kind of called for. Both the repetitions, because there is no stay.
There is a stay, sir.
And that both the repetition, my lord, that enclosures, my lord, that who was to be evicted, they have, one of the enclosures filed the case, whereas he was directed by the double bench to be evicted.
Maybe, but thereafter the single bench has passed a stay order.
So,
Get
my
that stay vacated.
lord, we are not made party, no?
File an application for impleadment. All right.
It not be that
The-
the order.
Writ petitions refer to in the order dated.
Both the petition may kindly be called for, my lord.
No, no, we'll not do that. There's a remedy of appeal if the writ petitions are decided.
My
Why
lord,
should we preclude that remedy?
And one of the other petitioners did not get the stay.
All right, they'll proceed against those persons where there is no stay, proceed against them. The writ petitions referred to in the order dated 8/5/23 have still not been decided. However, this court is apprised that only in writ petition number 729 of 23, the concerned party is enjoying a stay order. Thus, the authorities shall take steps against the other encroachers, if any.
And under it, on the, my lord, Lana Shinglo, then may dispose the case of the early date, my lord. Because that is pending for several months. Let it be disposed of, my lord, because the product might have been used.
List, let the compliance report be filed on the next date. List after 4 weeks.
Obliged, Lordship.
Very difficult to make out what he says.
Adjournment.
Yes. Service has not been completed. Plea of ignorance. Mr. Goswami, you've taken a plea of ignorance.
No,
All your affidavits, yes. We were not aware of the order of 2014.
in the affidavit by respond number 1, my lord.
Yes,
Because my lord, that.
the state was a party.
Served the judgment after a period of 6 years.
Mr. Goswami,
The party.
state was a party. State of Arunachal was a party.
My lord,
I means what?
RWD, my lord, that department was not a party.
Oh,
And the copy was served after the issuance of the tender.
state is a party in that proceeding, Mr. Goswami. Now you've been served the copy. What steps do you propose?
Now, my lord, actually, my lord, there are two departments involved, my lord. This is RWD's stand, my lord. The PWD's instructions have been sent to me, my lord. They have actually constructed the roads, my lord, as per scheme and the modalities which were sent to the central government, that, my lord. But only thing, my lord, the instruction they have sent me and the map, my lord, slightly obscure, my lord. I have called 40%. I need some time for PWD.
Mr. Goswami puts in
Then, my lord,
appearance
this will be
on behalf of the respondent number 3 as well.
no,
Three.
my lord, 1
2
and
and 3.
1 and 2, my lord.
1 and 2.
1 and 2.
Respondent number 3 is also chief engineer PWD.
No, that I have not got the instructions.
So all right, we'll
Therefore,
summon
this-
the respondent number 3 in the court then. This is contempt, no one is appearing.
My lord, I have only been asked. Is it
All right then.
proceeding, my lord? And my lord, some respondents are yet to be served. I have not, one or two respondents are yet to be.
4 and 5.
4 and 5 have not been served.
Also
3 has been served.
RWD.
3 is the chief engineer. You don't want to represent him.
My lord,
All is
I have not actually got, I have got.
All right.
instructions.
Service upon the respondents numbers
One
4
Mr.
and
my
5.
lord, one Mr. A Hussain is there, R3 and 6. His name is also shown, A Hussain, my lord, from the cause list.
R3
R3 and 6.
and 6.
I am appearing for 1 and 2.
All right, 2, 3. Service upon the respondents numbers 4 and 5 has still not been effected. Mr. Goswami has entered appearance on behalf of the respondents numbers 1 and 2.
Yes.
He prays for and is granted 4 weeks time to file affidavit on behalf of the respondent number 2.
Yes.
Since the respondent number 3 and 5, 6 contemners are not present in the court, nor their counsel is appearing, these officers shall be intimated to remain present in the court on the next date of hearing.
Much of it.
Next date of listing, re-notify on
Item 3.
29th August.
Obliged.
Steps for service upon, fresh steps for service upon the respondent numbers 4 and 5 be taken in 3 days. Whereafter process be issued. The rule is made returnable on date जो भी दिया उसका दे दीजिए 29, 28 जो भी. Yes.
Item number 4.
Yes.
Well, this is a review petition preferred by the state, my lord. While preparing the
review application, my lord, there's a delay of.
Well, we have filed our objection in this against the delay condemnation petition.
Mhm. Mhm. So you mean to say that we can entertain the review in respect of the fact that it is delayed? Mhm. That's all right, brother. If there is no specific provision is there,
I'm objection to
the party concerned has to show is the. That's it. No one will be contempt of the case. That's a different issue. But review. Definitely, I would feel that. it can't be closed. This is saying. Yeah, this is now in this case, they are pleased to take. I understand. It is in the considered. Yes, Mr. Katniar, explain your delay.
Yes, my lord. While preferring the delay.
You took a decision to approach the Supreme Court. Where is that decision?
In fact, that decision.
Where is that communication? Where is that discussion? Note sheets, nothing.
For that, my lord, I have to place that.
Law is settled. Every day's delay has to be explained.
That I understand, my lord. That
Let us see your explanation.
explanation, my lord. Well, in fact, there is one decision to approach Honorable Supreme Court, my lord, for preparing an assembly. While doing so, my lord, there was a screening process going on, my lord.
Where is that decision, sir?
That I have to, in fact, in the review delay application, that is not annexed, my lord. For that, my lord, I need some time.
Any dates mentioned?
No, my lord.
Then we can dismiss your application simply on this ground.
Well, give me some time, my lord, so that I can bring it on record.
Mr. Katniar, page for is granted 4 weeks time to supplement the application seeking condonation of delay with better particulars.
But my lord, we are not, in spite of a specific direction from this honorable court to implement the order immediately, they did not do it. We filed immediately a contempt petition. They did not purge the complaint. Today, after 5 years, my lord, of the judgment, they are coming again.
So you press your contempt.
My
What
lord,
is the
the
problem?
contempt petition, my lord, the last date was that unless they are awaiting the outcome of this review petition. my lord.
You file your contempt, argue on that.
We had already filed it, my lord. The last order in the contempt petition is that they said that we are filing a review. So the court did not proceed.
When
with
is
the
when is the contempt listed?
my lord, contempt case C number 536 of
List
2018.
on so and so along with contempt case number so and so.
In fact, my lord, subsequently, the cabinet took a decision to accommodate those illegal and irregular teachers, my lord. And some of them have already been accommodated, my lord. I will bring on record, my lord. That is my question. Obliged, lordship.
On 22nd August.
Obliged, lordship.
Item number 5.
May it please your lordships, this order relates to 2018 lordship, this contempt.
You want to file the affidavit?
Filed the affidavit, my lord.
When?
On 17, my lord.
It's not been received.
Not annexing the, my lord, notification, my lord, that we have already annexed it, my lord, and seeking the permission of the governor, my lord.
What do you say then?
Lordship, the procedure is still half done, lordship, because after the approval, they will still have to introduce it in the council, then only it will be passed. So
should
their
get-
responsibility
if it
is
is-
still not complete.
We should
If
get
it
the
is-
approval of the governor, then we can only.
The governor gives the approval, then only they can proceed.
Lordship,
They have done their part.
yes, Lordship, but then
Then-
since 2020, they have not followed up the matter at all, Lordship.
Affidavit on behalf of the respondents, contemners has already been filed by standing counsel, Mr. Chutia. The same be respondent contemptor kar dena. Same be brought on record. List after 10 days.
Item number 6.
Make Lordship. The step process has been taken, Lordship. According to
Not
the
on all, not on all. The report says that 2 refused. 2 have accepted, 4 refused. Still many more are there. Response numbers 5, 8, 10 and 12 refused. 4 and 14 received. What about 6, 7, 9 and 11? What is your affidavit? What does your affidavit state about them?
Okay.
Let's see.
But you mentioned the affidavit, Lordship, in para.
Okay, only these were to be served. 4, 5, 8, 12 and 14. Others have been served already. बाकी का रिपोर्ट क्या है ब्रदर? ये ऑर्डर क्यों? Why this order is uncertain, sir? What about 6, 7, 9 and 11 and 13? Why notice was not issued?
5, 11, 80% in respect of 6, 7, 11 and 13 has been received.
Received, all right. Then counsel for the plaintiff has filed an affidavit of the C service on the unserved respondents. In view thereof, comma, the service is presumed to be complete. List for admission.
Item number 7.
No one appears on behalf of the respondents despite service. These respondents despite service. Yes.
No applicable. Yeah, this melody impugnment, or judgment melody is melody page 84 and 90 to 93.
Is it in the whims and caprices of the government to keep on changing the notifications every moment? One day you fix 100 meters, the other day you fix 10 meters, the next day you go on 50 meters.
Initially,
Then what about the right to enjoy the land as per the constitutional provisions?
there is a act,
And why the notification will be retrospective? Let us know. They have started their construction before your
Yes,
notification.
that is true.
Then that is a simple question.
At the time, what
Yes.
there's a letter from the Air Force Authority, to take permission from the defense, concerned defense army, It was their, they did not took the permission from the respondent,
They were not supposed to. Your 16 notification says
Yes.
no permission required,
Permission.
no NOC required.
If up to 100, up to 10, it is required. Before it was 2011.
It was 100.
Yes.
It was altered to 10.
And
They have
and
taken advantage of the 10.
yes, and
What is wrong in that?
even then, there's a letter from the Air Force Authority that it is in record, it is required to take permission from the authority,
Under what notification? Under what provision of law, notification, ordinance?
This, so for our cases, even their wall is within 1 meter from the from the 10 meter, 10.
So is it your notification that no person can even purchase the adjoining contiguous plots?
This is our.
If person purchases,
So for construction
you
is.
see construction and a boundary wall. Boundary wall is a safety measure. It's not a construction basically.
But any
That's
construction.
too hyper technical an argument.
But this, so far the X is the any construction, this word is inserted.
Construction for your safety purposes,
Yes, my lord.
you
that is-
prohibit the construction.
Yeah.
So if they don't construct a wall, supposing your wall is there, the people who will use the hospital, they will come up inside the defense installation because they have not constructed a boundary wall. You want that to happen?
But it's for security purpose, my lord, then this is only the government.
This is an absolutely absurd argument, Mr. Mehdi, that you don't let them construct a boundary wall even though their plot is contiguous to your land. That is absolutely absurd. You are yourself putting the installation to risk by taking that stand. What do you say on that?
This is our case, my lord. This is only our case, my lord.
Yes, Mr. Saiwala.
My lord, virtually.
Why do you construct a boundary wall within 10 meters?
Demolished, my lord, virtually.
Already demolished.
Already demolished most of the. My lord.
All right, they've demolished. Now they'll enjoy
No, my lord.
scaling your walls easily.
Rather, my lord, boundary wall will give separate.
Mr. Mehdi,
My lord,
we'll note that your stand is creating a risk to the institution. You want us to do that? Imagine a hospital functioning without a boundary wall, people coming right up to your borders.
I'm not in that, my lord.
Then
The boundary walls should be from from some such distance, my lord, as per 2016 also, my lord, from the out of.
no, they will not construct it. Then what happens?
But it is there, my lord. It is there, my lord.
No, we are saying that they will abide by your direction and not construct the boundary wall at all. They want to use the entirety of their land. Why should they waste 10 meters? They'll enjoy. People will have recreation in that land, parking, everything. They have the security of the defense installation immediately next door. They'll use that land. Use is not prohibited, right? We'll make an observation that you have taken an objection
At
that
page-
boundary wall can't be
At
constructed.
page 155, photograph may be seen, my lord. That the wall has been demolished, my lord.
So once they demolish the wall, what will happen to your installation? Let us know.
Rather, that is for their safety also it is required.
My lord, but.
Direct access to the installation you are providing.
Our case only that, my lord, 2011 says fixed the different, my lord, and that is under review, my lord. And during that period, my lord, 2016 come, my lord, and this is under review.
16, they got the permission. They have raised their construction.
I admit that, my lord.
So there is nothing wrong in that.
That-
Now, you really insist on that boundary wall issue.
my lord, it's up to your lordship, because.
Do you want to take your instructions? Ms. Mehdi, you
Yes.
just see, you are yourself, we are repeating again and again. Your stand is going to bring great risk to the institution. It's defense installation. So what do you want?
On 31st, this matter fix, I'll take it. On 31st of that is July, matter fix, I'll take instruction. On that, your lordship will pass final order.
So we are making it clear that now your dispute is only regarding boundary wall. Nothing beyond that. Whether you want the boundary wall to be constructed or not.
Well, I'll take instruction.
Mr. Mehdi limits his arguments to the issue of boundary wall, proposed boundary wall being raised by the respondents within 10 meters of the defense installations precincts. He urges that the boundary wall cannot be constructed in this radius because the same would be violative of the guidelines dated 21/10/2016. However, Mr. Saiwala submits that the boundary wall has been demolished. He has shown the picture at annexure 5 in support of this contention. We feel that allowing the hospital to function adjacent to the defense installation without there being any safety of the boundary wall would rather cause a risk to the security of the defense installation. Thus, Mr. Mehdi shall take instructions from the authorities concerned whether the boundary wall should be allowed to be constructed on the land of the respondent or that the installation is ready to face the risks by the non-existence thereof. List on
31st July.
31st July.
Yes, much. File.
Item number 8.
The respondent 8, my lord, Deputy Secretary, the Hill Area Department, my lord, have issued, my lord, have accepted the notice through the government, my lord, and their affidavit is required. Since respondent 1 also have stated.
For respondent number 8, I prefer 2 weeks time. I am awaiting the instruction.
Okay. That you said on the last date also, Mr.
The respondent number 8 has been newly implemented.
Has been
Respondent number 8 has been newly implemented. On that day.
6 you appeared, Mr. Nath.
Correct,
Mr. Nath
Correct.
appearing for the respondent number 8,
Respondent number 8.
praised for and is granted further opportunity of 3 weeks to file affidavit on behalf of such respondent. List of 4 weeks.
Item number 9.
Yes, last date, a statement was made that payment has already been done.
My lord.
What is your stand?
My lord, as per my instruction, my lord, payment has not been made.
Then you're required to file something on record. Is the statement, is the document. Let us see the,
Let the documents be filed on in the form of affidavit, my lord, so that I can.
all right,
make a-
MS, so and so associate to Mr. RKD Chaudhary. Yes, please on record,
Yes, sir.
copy of the letter dated 15th May 23 in confirmation of the fact that due payment has already been made to the petitioner in terms of the order dated so and so. Due payment of arrears, copy of the said letter and the pay slips, etc. be provided to, and the due drawn statement be provided to the counsel for the petitioner who prays for and is granted 4 weeks time to complete his instructions. Get copies made and provided to the other side also.
My lord.
List up to 4 weeks.
Item number 10.
May I please, your lordship? Lordship, compliance affidavit we are filing during the course of the day, my lord.
Counsel. Mr. Your good name
As that,
is that representing the respondent number 1 contender proposes to file the compliance affidavit during the course of the day. List after 4 weeks.
I'll apply.
Item number 11.
We have served the dusty notice on the respondent, and to that effect, we have also filed an affidavit.
You have already filed.
Yes, we have filed the
It's
affidavit.
not on record.
Uh,
Mr. Nath submits that
And there is
dusty
office-
service
office note also.
has been effected. Office note is not there.
As regards-
Office notes, it says not filed, not received. Submit that he has already, service has been,
Yes, sir, we have filed.
service has already been effected on the respondent number 1. And the affidavit has been filed in the office. The registry to report and list the matter for admission if service has been effected on the respondent. For orders.
Item number 12.
So item 12 is a state affidavit. Lordship, may kindly pass over for the time being, my lord. Senior standing counsel will apprise the court, my lord.
Para 4 देखना brother. Para 4 of the appeal order. It's based on revision and judgment. They were regularized similarly. They are showing that regularized. Very well, pass over.
All right.
Item number 13.
May it please your lordship. This is appeal preferred by the state of Assam.
There were many writ petitions. What about the other matters? That was an entire bunch of
That's
matters.
a common judgment, lordship.
But you have filed appeal only in one.
Only one, no, one.
The others you will comply.
We can file subsequent also. They also filed in that way, lordship. One was main case, the other case was
Maybe.
subsequently filed.
Mr. Saikia, the direction is common for all
Common
the
for all lordship.
parties.
And this appeal we file within 24 hours of the learned single judges.
That is all right. That's all
We
right.
can file others also.
We don't know. That's your choice. Why should we advise you? All right. Issue notice.
I am saying for stay of the order, lordship, because prima facie there is a major error in the analysis of the learned single judge. The learned single judge relied upon a letter X of the central government, where one word was inserted, which is not there in the statute or the notification. That word is viscose. If lordship-
Viscose. Yes.
Viscose. If lordship is pleased to.
It's like, yeah, we have our reservations, whether you can restrict the trade in this manner. We have our serious reservations. Get them served. You already have a status quo order. You have not filed appeal against the other parties. So they will be enjoying the order of the single bench. The status quo is only in one matter. It can't operate for the others. Get them served. The status quo will continue. Issue notice to the respondents. Steps for service heard. Issue notice to the respondents. Steps for service be taken in 3 days. Whereafter process be issued, thus the service is permitted. Rule is made returnable on 4th August.
Status quo order that may be.
The status quo order of status quo passed on so and so shall continue till next day. However, we make it clear that the status quo order is operational only in the case of the respondent. Number 1. You are appearing.
My lord, I represent certain weavers, my lord, indigenous handloom weavers.
Are you appearing for the respondent number 1 in this case?
No, my lord.
Then-
We filed an intervention application, my lord, that may be brought on.
That will come up. That will come up. You will be, your interest will be common with the state. You file the application, we'll take it up then. Notice returnable on 4th August.
Item number 14.
May I please, lordship? Lordship, by this PPIL, the petitioner is praying for CBI or high-level inquiry against the guilty of officials of Guwahati municipal corporations who have given appointment to 500.
Issue notice to the respondents. Steps for service be taken. So and so appears. You represent Mr. Mazumdar, you will be appearing for Nayak.
Respond number 1,
Mr. Nayak, standing counsel, Mr. Nayak appears for the respond number 1.
3 and 4.
Finance 1, 3 and 4, Mr. Nayak. 2, Land Council, your good name, please. K. Surya appears for the respond number 2. MS Bora appears for the respond number 5. Copies of the writ petition be provided to Land Council representing the respondents. Service is complete. Affidavits on behalf of the respondents be filed within next 4 weeks. List thereafter.
Item number 15.
There are 19 they called. Here there's nothing at all. This has to be dismissed with cost.
Page 16, lordship, direct recruitment.
Already seen. They are not going to turn up. None present for the petitioner. List up 4 weeks. for the appellant.
Item number 16.
For 15. It's okay.
We have filed the affidavit on 17, my lord. That is on not the record, my lord. By the principal
17th.
secretary. 17th.
Standing counsel, Mr. Truthiya submits that he has filed affidavit
On behalf
on behalf of the council, principal secretary, KAC on 17 July. The same be brought on record, list of 2 weeks.
Item number 18.
Very feasible. Before my learned seniors start, today I have filed a reply. Probably it is not already filed, reply is filed. Today I have filed reply to the additional affidavit filed by the appellant. Probably it is not in the record.
Additional affidavit.
Additional,
You've got a copy, Mr. Mehta?
yes, today morning.
Yeah, this morning they have just given.
Okay,
We can otherwise proceed, my lord, if the record is called for, no problem there.
as you say,
Because
All the
here it relates to only an issue which is not directly involved here.
very good. Okay,
Because here, lordship will kindly see.
so we will call for their reply, then we'll take up the matter in the second round.
After some time.
In the second round, yes. Pass over. Transfer.
Item number 23.
Malicious. Transfer is malicious on the face of it. Mr. Nair, have you filed the affidavit?
No, my lord, what had happened here, my lord, we were in a discussion with they also, and I had also interacted with the management. I've explained to them that this may not be sustainable, the court may come in.
Mhm.
But my lord, the problem they are facing is that this has been going on in that district for a long time now.
Mm.
So immediately, my lord, taking it away completely,
So you want the court to step in?
my lord will step in. My lord, what I have advised them is, this is my lord between this, I have advised them is that a percentage of the post till a particular category be retained for the district, a percentage,
Mhm.
a reservation be made, the rest be made open to
Open to all.
all the people.
Mhm.
Now, my lord, this would require certain discussion with the, my lord, stakeholders.
Mm.
So I'll require, my lord, sometime, I'll come up with that. If your lordship, then my lord passes an order, maybe the issue
What do
can
you
be
say,
resolved.
Mr. Bhagwati?
Because otherwise there might be some unrest there, my lord.
That's likely, that's likely.
That's the only worry, my lord.
Lordship, in fact, the rule doesn't have a signatory, lordship. The rule they are
But that has
passing,
been
lordship.
going on, my lord.
It's a practice which is
Practice.
prevailing for
Long.
decades, we would
That's a
say.
simple guideline, lordship, they are following.
And that's true, but that's going on for
Lordship, lordship,
decades.
I understand, I
They
understand.
are actively
Lordship,
considering the matter, my lord.
Mr. Nair submits that the employer is in active consideration for amending the provisions of domicile reservation.
Lordship.
And that the process would require some time as all the stakeholders would have to be consulted. He prays that the matter may be deferred by 6 weeks
Lordship. More than enough.
so that a reasonable proposal can be placed on record
Bring it on.
for the court's consideration.
Much obliged.
List after 6 weeks.
Much obliged.
As agreed.
Item number 24, along with the item 40 of the supplementary list.
Well, here I'm praying for some more time to file our affidavit.
Affidavit. Ms. Katniar prays for and is granted further opportunity of 3 weeks to file affidavit on behalf of the respondents.
I'm obliged.
Item.
But there is also finance in this. You are not representing the finance.
No, my lord.
Then what about your affidavit
Lordship will file the affidavit.
as well as इनका भी लिख दीजिएगा. Both of them, 3 weeks.
Item 40.
40 also.
Obliged.
24 and 40. 24 and 40.
Connect kar dijiyega. Connect both the petitions. Item number 40 also.
Item number 25.
May please your lordship. Lordship had directed by the order.
Has the latest report been?
Lordship, actually, I received the status report, Lordship, and I prepared the affidavit also.
Hmm.
The thing is that the annexers are quite illegible, Lordship. That's why I could not file it today, Lordship. So I need
She
to.
has raised a valid concern.
Yes,
It
Lordship.
deals with the health of all persons who are interested in this kind of diet.
Affidavit is with me only, Lordship,
Then
but the annexers are illegible.
Are the scientific reports available? Latest?
Uh,
What does your affidavit say?
Lordship, the whatever they are saying, Lordship, we have received the report of the other institutions also. The formalin is and in the limited this means
Within
limit,
the
yes.
limits?
Yes,
Okay.
within the permissible limit, Lordship. And we are filing the affidavit, Lordship. Kindly allow me 1 week time.
MS
In
Bhattacharya.
fact, my lord, if I may bring one more point to your lordship's notice.
Yes, yes.
Fish is being imported by the state of Meghalaya also from other states. And in the state of Meghalaya, in the month of June itself, the importation of fish has been banned, my lord, due to the presence of formaldehyde.
You bring the decision on record.
My lord,
Bring the decision.
I'll place on record
Place
the
it on record.
notification.
The MS Bhattacharya submit that she has received the details, requisite details, and would be filing the affidavit, fresh affidavit within next 2 weeks.
Lordship.
List on 8th August.
Deeply obliged.
Obliged, my lord.
Very good.
Supplementary list, item 30 to 33.
Review. Oh. Yes, Mr. Nath.
They have registered a case.
You registered a case? All right, let it be investigated. Mr. Nath has placed on record copy of the communication forwarded from the office of the Deputy Commissioner of Police dated 18 July 2023, as per which, an FIR has been registered at the PS Baralumuk. FIR number 220/23 has been registered at the PS Baralumuk for the offences punishable under sections 325, 294, 506 and 34 of the IPC. The investigation of the said FIR shall be conducted expeditiously. Latest factual report shall be submitted for the court's perusal on the next date. Re-notify on 9th August. Mr. Counsel, now you need to take a decision. If you continue with these petitions.
No, my lord, it is better for me to not to make
Sure,
further
that's-
investigation.
that's-
Submission, my lord.
Absolutely your choice. What do you want?
I close, my lord.
At this, faced with this development, then counsel for the petitioner submits that his client would be better advised not to proceed with these review petition.
Yes, my lord.
Accordingly, the review petition as well as IA number so and so are closed. What about these two other review petitions? Same. You are representing in all three?
Yes,
All right,
all four, my lord.
closed, all four.
33.
Because monitoring by this court
I know, my lord.
could cause problems to your clients. So no need to, status report still you present. The status report of investigation shall be placed for the court's consideration.
To the redistribution.
No, for the court's consideration. We'll list it for receiving the status report
Lordship.
for the court's perusal. List the matters for receiving the status report on 30th August.
Lordship.
Item number 34.
May I please, Lordship? This I is for delay of condemnation of delay for 32 days, Lordship.
What do you say?
And in fact, Lordship, when it's, in a bad.
Delay condemnation, any objection?
Only one thing, my lord, that appeal was filed on 25/6/2020 and delay was filed on 29/12/21. That is 547 days delay. So we had.
My lord, my lord, connected appeal, my lord, there are 7 appeals, my lord.
They have already been admitted.
Lordship, and in 2 appeals has already been fixed for hearing, Lordship, on the last date I mentioned.
All right, delay condone. Connect with so and so, the connected writ appeal shall be, ITS shall be registered and listed for admission after 1 week.
Deeply obliged. 35 is same, Lordship, after the.
Same order.
Deeply obliged.
Item number 36.
Lordships, may I please, your lordships? I got the names of legal hair today itself, lordship.
Names of?
Legal hairs of respondent number 15, lordship.
Okay.
So I need.
MS
more
Bora
time.
submits that she has received the details of the LRs of respondent number 15
Yes.
today
Yes.
and would be taking the requisite steps
Yes.
within 3 days.
Lordship.
Office to proceed.
Item 37.
That is, in this case, my lord, we have taken step on 3/5/2020 on the private respondent, my lord. Now, my lord, has more than a month have gone by, my lord. Neither ID card there is.
Then you take fresh steps.
Or my lord, can it be sent to Lojima for a proper order there?
All right, Land Council submit that he has already taken steps for service on the respondent number 6
On 3/5/20.
on 3/5/23. The Lavazame court to report and list the matter thereof.
Item number 38.
My please, your lordship. Lordship, I am appearing for respondent number 6, my lord. And I am praying 1 week time to reply to the IAM.
Land Council, what's your good name, sir?
MR Khandakar.
MR Khandokar appears, puts in appearance on behalf of the respondent number 6. He prays for and is granted 2 weeks time to file objection in the interlocutory application on behalf of such respondent. I'm obliged.
Item number 39.
May it please, your lordship. My lord, here there is a delay application, my lord. Yesterday, I was submitting on delay application, my lord. Today, just I want to submit on merit, my lord. Only.
Why should we allow you to argue?
No,
on that?
yes.
Why should we allow? If you dismiss your application, your writ appeal goes automatically.
Is that I
Then
understand, my lord.
why should we
But
consider?
only one aspect I want to.
Yes.
Page 180, my lord. 180 of the writ appeal, my lord.
Then over here.
2 paragraphs, my lord.
Mm.
I'm relying on 2 paragraphs, my lord.
Just a direction to pass a fresh order.
Yes, my lord.
And you're still in appeal. Why?
Because, my lord, do you,
Why this adamancy on part of the state authorities?
no, my lord, there is subsequent development. That is why, my lord, we have preferred this.
You bring that subsequent development on record when you consider the case again.
That was, in fact, in the impugn order that was considered. May I kindly come to page 180, my lord. 180 of the earlier order by the Honorable Single Judge, my lord.
You see, your officers are not ready to apply their mind, then what the court will do?
Just for a moment, my lord. Just for a moment, my lord.
Yes, all right, 180.
Page, paragraph 11, my lord.
Yes.
Creation of supernumerary post with effect from 1/9/2004 for the concerned litigants suggests that vacancies were not available when the appointments were given in the North Lakhimpur subdivision on the basis of the so-called select list dated 5/3/2001. Moreover, the ongoing screening process undertaken by the Education Department was also under court's order, and the learned judge himself clarified that opinion is not expressed on the merit of state screening process. In my perception, the verdict in WPC number 3408/2012, Hemchandra Bora and 32 others, does not confer absolute legitimacy to the appointments made from the list prepared on 5/3/2001 by the North Lakhimpur Subdivisional Level Committee. In fact, the court had no occasion to determine whether the list prepared on 5/3/2001 was ever published or authenticated by the DE as required by the rules with due regard to the vacancies available for appointment. Therefore, the validity of the list under the elementary education rules will have to be decided by the authority. So, my lord, this screening process, my lord, that was undertaken during the pendency of the writ petition, my lord. And in the screening process, she was found to be irregular, my lord. That is the finding in the impugn order, my lord. Impugn order at page 185.
Question here is, Mr. Katniar, the judgment dated 5/9/17.
Yes, my lord.
The direction was to take an independent view.
Yes.
What you have done thereafter?
In fact, in this earlier, then paragraph 13. On the other hand, large number of litigants whose names figure in the list of 5.
And that judgment also reads that one conclusion was that the petitioner was entitled to parity of relief.
Yes, my lord.
With 33 assistants.
That is there, my lord.
So what have you done to that observation? That observation stands.
Yes, my
It
lord.
has attained finality.
Yes, my lord. That is there, my
How
lord.
could you have taken a different view then? Is it not a contempt rather, we will say?
Because while this order was passed, my lord, thereafter during that period, the screening process was going on, my lord. Thereafter, the cabinet took a decision.
So then you could have filed a review of that order. That was the remedy available. But you couldn't bypass that order.
Subsequently, my lord, pursuant to this order, my lord, the impugn order has been passed.
Yes.
And against this impugn order, my lord, they have preferred this writ petition, which order is under appeal, my lord, right? Presently, my lord. Here also, my lord, in the paragraph number 9, page 192.
Now we come to para 12 of the order under challenge.
At page 193.
Yes.
Yes, my lord. Resultant thereof, the impugn order dated 31/10/2018 has been passed. Upon perusal of the order dated 31/10/2018, it is noticeable that the Commissioner and Secretary has endeavored to make an independent assessment on the claim of the petitioner without binding itself to the requirement of the judgment dated 5/9/2017. The Commissioner and Secretary went to the question that in the recommendation of the expert committee, the petitioner was in category where she was recommended not for any kind of regulation of for salary. Secondly, the Commissioner and Secretary also again goes back to the question that the petitioner was appointed against a non-existent post. When there is an effective adjudication by this court that the petitioner is entitled to parity with
Mr. Katniar, we are rather compelled to observe that we should initiate contempt against your officers. Suo motu. This is adamancy of the highest order. You keep on doing whatever you want. We will behave as we like. That is what their stand is. We direct your secretary to remain present here. Let's put him a question. Why shouldn't we proceed for contempt? What do you say? Then we are making that observation right now. Contempt of two orders, 2017 and now the fresh one also.
Because only our concern, only the subsequent screening process. That is why that order was passed. Nothing else.
The right of that litigant was crystallized in 2017. There is no dispute about that.
Yes,
after that, whatever subsequent acts you have taken, they are immaterial, irrelevant. So on merits also. So we'll note that you argued on merits also. And our findings will be on both the aspects.
I'm obliged.
Okay. Dismiss. This is item number. Yeah.
Passed over, Mr. Item 12.
Your lordship, this is against the judgment dated 5/8/2022. Your lordship, the impugned judgment is page number 131.
Read para 4. The impugned judgment is not an independent adjudication. It just follows the earlier order of division bench. How are you distinguishing the case of the respondent from that judgment? Let us know.
Yes. Your lordship, the our humble submission is that, your lordship, the petitioner's case will not governed by the earlier division bench judgment.
Read your pleadings in the appeal
Yes, your lordship.
to this effect.
Yes, your lordship.
Why it will not be governed by that judgment?
Your lordship, at page number 17 on my appeal, your lordship, paragraph
Let's see.
12, your lordship.
Let's see.
Your lordship, the may read, your lordship. Your lordship, the court of the learned single just failed to appreciate that notification dated 17/3/2011, whereby it has been ordered to be benefit of the provisions of the Assam Panchayat Employees Provincialization Act 1999, including pension to be applicable to the.
Gentlemen, the direction of the division bench is service will be counted from the date of initial appointment.
Your lordship, the here, your lordship.
You may provincialize the services as and when you deem fit. But the division bench has laid down that the date of appointment shall refer back to the date of initial appointment.
Your lordship, the at the time of the death state of litigants, your lordship, when their services were provincialized, your lordship, the old pension rules was still in existence, your lordship. And so far as the writ petitioner is concerned, at the time of his provincialization, your lordship, NPS came into existence.
The view taken by the division bench is the appointment shall relate back to the date of initial joining.
Your lordship,
What would be the effect of that,
yes,
that direction?
your
Let's see.
lordship, the kindly see, your lordship, the page number 63,
Yes,
his appointment order, your lordship.
appointment is not in question, sir.
Your lordship, kindly see, your lordship.
Yes,
As the post is yet to be sanctioned at this stage. So he was appointed against non-sanctioned post, your lordship.
yes,
Posts were not in existence, your lordship.
yes. And come to annexure 2.
Your lordship,
Come to annexure 2.
annexure 2, your lordship.
Regularization. When was that done?
The regularization was done, but against non-sanctioned post.
Maybe that is your problem.
But
A regularized employee, you may take whatever stand you want. Pay scale has been granted on 10/6/2003. On that day, the old pension scheme was prevailing. You can't dispute.
Your lordship, they are claiming the benefit under Assam Provincial Panchayat Employees Provincialization Act 1999, your lordship. Your lordship, they may kindly see the Provincialization Act, your lordship. Panchayat Act. 367. Yes, 57.
Will you come to page 69? A service book. Page 69.
Yes, yes.
In pursuance of the government order number so and so, dated 30th May 2003, dated so and so, service regularized to a scale of pay with effect from 10/6/2003. What more remains thereafter?
That is admitted, your lordship.
So then,
Again,
he was a regularly serving employee on 10/6/2003. Your new pension scheme came into force in 2005.
your lordship, there was no such post, your lordship. Without any post there, your
Then why
lordship.
did you regularize it? Regularize the service?
So your lordship,
Recall this order.
subsequently we have realized it, your lordship. So that is the your lordship post were created in the year 2006. And your lordship, their services are, his services is provincialized.
Let us see.
He accepted that provincialization order, which is conditional one, your lordship.
Was the
So
regularization
where in
order?
2006, he has accepted that provincialization order, and his challenge in the year 2002, your lordship. After his
Does the
supervision.
provincialization order says that this provincialization is being done because the posts have been created now?
Yes, your lordship.
Read.
Case number 77, your lordship. The governor of Assam is pleased to regularize and provincialize the services of 1,707 numbers of
Yes. The cause of action arose to these people when you pass the order at page number 125. Read that. There is an ex post facto approval to the post. It will relate back to the original date. You may mention anything in this order. Read page 126. Ex
Yes, sir.
post facto approval of creation of so many posts with effect from 30th May 2003. So
your
the
lordship,
date would relate back to that day. The posts have been approved from that day. Nothing remains thereafter.
your lordship, this order was passed for a limited purpose, your lordship, because the another repeal was
For whatever purpose it was passed, it has the
And-
effect of the post being created in the date.
even then it was
The-
issued, their order also issued in the year 2018, your lordship. They
Yes.
have accepted it. They are regularly contributing towards NPS account, your lordship.
What option did they have?
Your lordship, it is,
You recover that amount, you'll get back that amount. That will have to be paid back to them.
your lordship, kindly see, your lordship, since the provincialization order is a conditional one, they have accepted it. They have given the undertaking, your lordship.
Okay.
Now in the
very well.
such a belated stage, can they say that the favorable part will be accepted and the other part will be rejected, your lordship?
They can very well say because the division bench has said so.
Your lordship, in that point, your lordship, I would like to refer to Supreme Court judgment.
Read, please, read.
Paragraph 30, your lordship.
Yes.
2009.
This is the case of seniority, Mr. Counsel. There are dozen judgments on pension that the date relevant would be the date of regularization, not one. Wherever financial benefits are to be conferred, the date of regularization is the regular date, the relevant date.
Your lordship,
Bring one judgment wherein the question of financial benefits is involved and the date of regularization has been treated to be a subsequent date. Bring one judgment of Supreme Court.
Your lordship,
The date which has been accepted is something different from the date of regularization. Give us one judgment.
Your lordship, the ratio laid down in
This
this particular
is
judgment, your lordship.
inter se dispute of seniority. Then, of course, ad hoc and regularly selected employees. The issue was decided in favor of the regularly selected employees. Herein, the issue is of financial benefits. We are telling you again, give us one judgment. That the date of regularization can be treated to be something different than what is indicated in the documents.
In this also, your lordship, in this particular judgment also, your lordship, the regularization order was itself a conditional one, your lordship.
The regularization order was passed in 2003. At that stage, you say that posts were not existing. You approved the post ex post facto, right? So it has to relate back to that date. this order by itself conveys that the post will be deemed to have been created on the date the regularization was ordered. Now, this is a case of one employee. What about the others? What you have done to the others? There were 1,700 persons. How are you treating them?
Your Lordship, their case in a before a learned single bench, Your Lordship, their association's case is
Pending. So
Pending,
let
Your
us
Lordship,
put that
that
to
means, Your
finality.
Lordship, hearing is completed. It is now reserved for judgment. Your Lordship.
So all right, let us put them out of misery. Anything else to say?
So in this matter, in this case also, in the writ proceeding, Your Lordship, before the learned single judge, Your Lordship, we are not given the opportunity of filing even the affidavit in opposition, Your Lordship. Some reasonable opportunity may kindly be given also.
You are in appeal, your pleadings are here.
Yes.
We'll read all your pleadings here. Don't bother.
Your Lordship, the Lordship is asking for a judgment, Your Lordship.
Yes.
Your Lordship may kindly accommodate us
Friday.
for 1 year, okay, not 1 year, 1 week, Your Lordship. We'll come back.
Come on Friday,
Next week, Your Lordship.
this Friday.
Oblige.
You have like your.
First over matter, item number 18.
Yes. The other side, sir. Other side has just come.
Disappeared. Maybe they are afraid of you.
My lord, it was the lordship said in the second half, that is why probably he went out. I was sitting for item 29. Other items are there. That is why.
And that's how we proceed, sir.
Yes. Yes.
He's here.
Yes,
All right.
yeah. Yes. Oh, oh my God.
Affidavit aa gaya na? Yes.
Lord, lordship here. No, no, don't get to the level I have now. It is. That's what
Yes.
But the affidavit just filed today, that relates to the affidavit we have filed showing that the school management committee took decision to fight out the writ petition and also to go on appeal when it was decided against it. Lordship earlier wanted whether the secretary who is now representing the dishonorable
Yes.
was authorized to file. Lordship will find that affidavit that was filed by us. Not take file to say, "Kun idea kariya." It was filed on May, 10th, May 2023. That affidavit lordship will find at page 138.
Will you like to read para 4 of the affidavit? Which has been filed now?
135, the running page 135.
157. The affidavit which has been received today.
Oh. That the deponent begs to submit that in the meeting dated so and so, nine numbers of signatories were shown to be present, but none of them are belong to senior teacher of the school. Having no knowledge of computer technology for monitoring of ICT-based education to be nominated by the inspector of schools, not a member of the Antalik Panchayat. Signatories are not present of the Gaon
So
Panchayat.
the allegation is that the meetings were convened when the SMDC was already defunct.
No.
That's
No.
what the affidavit says.
It is his allegation. Let the government say whether SMDC is functioning or not.
We'll
SMDC
ask,
is function.
we'll ask the,
He's
we'll
a
ask the
private
comment.
person.
We'll ask the comment.
Yes,
Hmm.
the SMDC is working, SMDC has set, SMDC has decided, and those who are not today, those who are there since, well, when
Yes.
these committees were there. Therefore, in my affidavit, Lordship will find, in my affidavit, page 138, Annex 1, that was the first meeting relating to this case.
What is the tenure of the SMDCs?
SMDC's tenure is
5 years.
5 years.
5 years.
Read para 10, sir.
Department expressed that the appellant is the member secretary of the so-and-so, which was constituted by the inspector of schools with his order dated 16. The term of SMC already expired 21 and therefore same is invalid and defunct. Now that has been extended. That is how they are working.
Where is the extension order?
That is how they are working. Otherwise, how can?
Where is the extension order, sir? Mr. Katniar, what is the stand of the government?
Place it, Malak, if there was, if that was not there.
The government is not agreed with the order of the single bench.
No, my lord. In fact, before the landed single judge, my lord, we have produced our record, my lord. And after perusal of the record, my lord, this order impugn was passed, my lord. Paragraph 6, 7, and 8, my lord.
Major issue to ये है, उसका seniority का
2021, valid and defunct. It's already expired,
No, no.
2021, no?
on his own request, on request.
Yes, look at it.
Mr. Manta,
My lord.
the primary issue for the court's consideration is how can you act to the detriment of the service career of the employee by transferring him so that he loses his earlier service?
No, my lord, I respectfully differ, my lord. Here the issue stands purely on the different ground. That is what the learned single judge failed to.
And then the
consider.
second fact, you mentioned in the transfer order own request. He has never made a request.
My lord, that is for the government to take care of. I am not on that.
The government, what is the stand of the government? Was it on own request?
Government
No,
now here in the affidavit, they didn't file affidavit there. They here now say that the petition, they have challenged it. This petition, there is no case. That is what they have said here.
Page 76, my lord.
76.
76 of the impugn order.
By itself, by that very fact, the transfer order goes page
Page
75.
76, page, paragraph 8, my lord. The learned standing counsel of the education department has assisted the court in perusal of the records and no record to be shown that the petitioner has exercised an option to be transferred.
The order is bad on this very ground only.
Hello?
The order records on own request. Whereas the fact is that though there is no request.
My lord,
The order is vitiated on this ground.
that is for them to explain how they did act. But as my lord, we are not against an individual. We, the committee has come, the SMDC has come in the interest of the school. Our plea is.
Again, persuade the government, transfer him, he is not feasible. His services are not required.
They are otherwise required to take some action in the interest of the school.
So,
Therefore,
the government, no?
government.
So already file a writ petition for that purpose. File a writ petition. How can we act against the individual's
No,
interest?
that is why Lordship is right. In that way, we may have to come again with another petition.
Yes,
But
that is what the
here-
only remedy
Here
is.
is a case
Yes.
that keeping apart for the time being. Here is a case whether,
Yes.
here is a case whether the transfer order which was passed by the authority just to meet the situation. The person was creating havoc in the school. That is an admitted.
Understood, sir. So you persuade the government officers, authorities to take action against him.
Well, they issued
But-
a notice first, so-called
Yes.
notice, then they issued the transfer order. Just
So
to
that is
save him.
punitive.
It is
That
not a
is
punishment.
punitive by violate records that it is on own request, wrongly records.
My lord,
What the court is supposed to do.
My lord, that is why I am saying, it is for the authorities, they have recorded. it,
Authorities are
so that
now
they
not
have-
interested in taking action.
My lord,
You file a writ petition for that purpose. You can't now come against this order wherein the transfer has been interfered.
but there are two parts in the order. First part, there is a power to transfer. That is always there. Now the second part relates to his seniority.
Power to transfer lies with whom?
Lies with the government.
The government is now not interested in.
The government has exercised their power, but he says ultimately
that exercise of power has been found to be vitiated because
Subsequent part, it says that the transfer order will dishonorable him for his seniority. That part. That part.
not only seniority, Mr. Mahanta, it wrongly records that it is on his own request.
Well, that is of course. That
So,
is of course, if
then-
there is no record.
It's a fact mentioned in the judgment of the single bench.
Malad,
You satisfy us to the contrary.
No, I cannot.
Then what is
Because
there in the
this is
appeal?
Not in my control. That is in their control.
So they have shown the record. A record says there is nothing
So
of
then
the
in
sort.
that case, Malad, no, what I find, Malad, I was basically.
They could not have done it, sir. They could
They
not
could
have
not
done
have
it for
done
the
it.
reason, for the simple reason that if it is a punitive transfer, it affects his service tenure.
True. I. do
That
not
is why they
dispute
showed it to be a transfer on request so that you could be satisfied.
it. No,
that is the only
no,
thing.
No, Malad, I will respectfully submit. There is no question of my being satisfied. What I will say, Malad, maybe he was asked to, and he was taken into confidence while passing this. And he must have
All
agreed.
request has to be a request in writing, sir.
He must have agreed, but it was not in writing. Many
That
things
is
happen.
all things in contemplation.
Malad, but true, but then that order says something which was not on record.
So record
That by
speaks
itself.
against you.
Now
sir.
the question, the whole question relates to ultimately the school.
We understand, sir. So you approach the authorities if they don't act as per your requirement or as per your feelings and sentiments of the school children or the parents or the committee,
well,
then
that
you
is-
file a writ petition. That is the remedy.
Well, Lordship may kindly with that liberty close it.
We can do that, of course. Yes.
With that liberty, because we are not against the individual as such. No,
After arguing the matter for some time, Senior Counsel Mr. Mahanta submits that as the entire atmosphere of the school is being polluted and tainted by the activities of the respondent, the
private response.
private respondent,
Yeah.
the SMDC may be given liberty to approach the department with a complaint against such respondent. And in turn, the authorities may be required to consider the complaint of the SMDC
Along with the
objectively,
complaints already filed.
along with the previous complaints already filed
Yes.
objectively.
Yes.
Mr. Mahanta, now there is a problem. He has raised a dispute that you are not even in existence.
Well, let the authority say that our representation, he can take care of that also.
We may at this stage, take note of the submissions in the affidavit dated so and so filed by the respondent number 4,
At least.
wherein,
Before.
he has raised objections regarding the very existence of the SMDC by pleading that the tenure of the committee has come to an end in the year 2021 itself. Needless to say that as and when the complaints of the SMDC are being considered, the authorities will remain cognizant of the fact whether will be required to remain cognizant of the fact whether the tenure of the SMDC concerned continues.
Yes.
So stop. The complaints filed by the validly operating SMDC, if any, shall be considered objectively.
And also the public complaint. Madam.
Public complaints, we are not going into that, sir. Right now, we are in the appeal by the Secretary of the SMDC only. With the above observations, the instant appeal is permitted to be withdrawn.
Lordship may say closed.
Is closed.
That's one observation. Lordship. So far, the respondent number 4 is concerned, he also filed affidavit. Now, before the complaint lodged by the SMDC, Lordship, actually, I filed a complaint petition on 15th of June.
Take your whatever course of action
That
you.
may also be taken into consideration.
No,
because this
we
is
are-
pending.
We are on
Lordship,
the
kindly see,
appeal of the SMDC. Why should we make any observations regarding your client?
this complaint is against this SMDC. also.
Maybe, so you
Because
keep
they
on,
have misappropriated the money meant for the midday meal.
take whatever remedy you want to do in that regard.
In paragraph 8, I have stated, Lordship.
These are all manufactured. Many things will come out.
They have not denied it.
Thank you, gentlemen.
They have not denied it, Lordship. And otherwise, also, how he is agreed by my transfer order, Lordship.
Next case.
All right.
Apply, Lordship.
इसमें एक लाइन और ऐड कर देना in view of the fact that the state has not come up in appeal against the order of the single bench interfering in the transfer of the respondent number 4, Mr. Manta frankly concedes that his client would be better advised to take recourse of the suitable remedy of prosecuting the complaints against such respondent with the authorities rather than pressing the instant appeal. The interlocutory application is also disposed.
Daily list for hearing, item 28.
This is a lordship. Lordship, I'm the petitioner in person here, lordship. This
What
relates,
is your PIL about, madam?
this relates lordship में peruse, order dated 24/9/2020 when a few issues were framed in the.
Mr. Sakia,
We have filed the affidavit yesterday, lordship, of 3 departments.
I've
you received the
copy.
affidavit?
Yes, lordship. I've received the copies.
So we need to bring them on record.
Yes, lordship.
Mr. Sakia submits that he is pursuant to the last date of listing, fresh affidavits have been filed on behalf of 3 departments, namely
Four, lordship. Respondent 5 and
Transport
8.
Department, GMC,
Not
Smart
GMC,
City,
Smart City.
and the Deputy Commissioner, 4.
and the
Deputy
the
Commissioner was
same
not
be brought
noticed.
on record. Copies of the affidavits have been provided to the petitioner appearing in person. Mr. Saikya, how long will you take for this flyover to be completed?
The government has given them time. They have time actually, but government has postponed it to 31st July. It will not be completed, but little bit more, but it will still be much ahead of the schedule time.
What was the original schedule?
Original schedule, lordship, I have to look it.
Somewhere
Because-
in 24, lordship, but.
Yes.
that is-
No,
that's
no.
not
Why-
correct.
When was the construction started?
It started about 1 year or little bit more than 1 year.
Only?
Yes.
2 years. lordship.
In fact, the Ganeshguri flyover
Hmm.
and 2 other flyovers, it was constructed about 18 months earlier or even 10 months earlier.
That is the main bottleneck we
Yes.
can see. People are
Once
stuck.
this is done, lordship, then the major problem will go, lordship.
Absolutely.
And in the meantime, lordship, other departments may file their affidavit if they have any, because in the issues, certain other points. which-
Affidavits on behalf of the remaining departments may also be filed. Affidavits of latest status reports on behalf of the remaining departments may also be filed in the intervening period. Re-notify on 11th September.
Highly obliged, lordship.
Item number 29, along with item number 50 to 54 of the supplementary list.
Yes, ma'am. In this case, lordship, on the last occasion, lordship was directed, I have placed the records, lordship was pleased to direct me to place the decision of the government of granting grace mark on record
Okay.
through an affidavit. Somehow we missed it. We are filing it today, lordship. It was ready, but it was not signed. So we are filing it during the course of day. Let the matter come up on Friday, lordship.
Ms. Saikya submits that the decision of the state government to grant grace marks could not be brought on record owing to some inadvertence. However, the same would be filed on record during the course of the
During the course of the day, lordship. I have a copy of this also, but
re-notify on 25th July.
deeply obliged.
All the cases, use the
25th July, lordship.
25th July.
Highly obliged.
Supplementary list for hearing, item 44.
Let me move to issue line.
May I please, your lordship? Lordship, on behalf of the appellant counsel, I beg after some time matter may be taken up, your lordship.
Today,
Today, your lordship.
password का hearing matter में क्या password है? Madam, hearing matters, what is the purpose of passing over? Re-notify on so and so. Re-notify after 2 weeks as paid by counsel for the appellant. Who's for the other side? There's no one.
I am Mujumdar, your lordship.
H. Base Barua. You are in 44.
I am in 44, your lordship.
Mr. KL is there.
Yes, your lordship.
On the other side, the name shown in the cause list is Mr. H. Base Barua. None present for the respondent condition. Okay. list after 2 weeks. ये तो बंच है कोई क्या है ये देखा क्या आपने मैंने तो नहीं देखा हियरिंग फाइल नहीं देखा हमने
Item number 47.
Yeah, please, Lordship. Lordship, in this matter, we need some accommodation.
What is the petition about?
Petition is about non-issuance of ration,
Hmm?
non-issuance of ration card.
Non-issuance of ration card.
Yes, Lordship.
Counsel for the petitioner, please for time. List after 4 weeks.
Deeply obliged.
Item number 48 and 49.
Matters were called out for hearing, none present for the appellants. You're there? For the respondents, none present for the appellants. List after 4 weeks. Called out होगा Mr. Robin. Called up नहीं, called out. Yes.
Item number 55.
50 to 53, they have gone on 25th now. Yes. 55.
Lordship.
Yes, Ms. Bhagwati. What is the matter about?
Lordship, they are seeking pension according to the old pension schemes, Lordship. Lordship, there are certain orders of this honorable court as well as Lordship, the apex court, Lordship.
Okay.
May I place it, Lordship?
Sure.
They were selected prior to the introduction of the new scheme, Lordship.
Okay.
So Lordship, they were
Selected on regularly selected.
they were selected for compassionate appointment, Lordship.
Compassionate appointment. Okay.
Lordship, already they were selected and they were awaiting appointment because they were not appointed. They even approached the honorable
The appointment orders were issued later.
Lordship.
Selections are done, the appointments to come. Mr. Bhagwati, we have a doubt in our mind that the actual relevant date would be the date of appointment. Can't be the date of selection.
That is the apex court have issued some orders, Lordship.
Let us see.
Lordship,
Precisely on this issue.
I placed it, Lordship.
Not my fault, the appointment order was not issued. Let's see what judgment you have referred to.
Lordship.
Which one? Which judgment you are referring to?
Lordship, there are four
B.
judgments,
Ranjit
Lordship.
Raj. Read.
Relevant part, Lordship, Lordship in Lordship P. Ranjit Haraj.
Let's see. What is the issue?
Lordship, paragraph 5, Lordship. Mary, Lordship. So far as the present appellants are concerned, their names at the given point of time were withheld for want of further verification clearance from the commission. Lordship, I may go to the last line. Despite all the formalities being completed without any reasonable cause or justification, the state government withheld the appointments of the appellants, and finally both the appellants were appointed on the post of APP grade 2 on 23rd August 2005 and 23rd April
Mr.
2004
Bhagwati,
respectively.
read para 4. Were appointed on the post of so and so by order dated 24th September 2002. There is an earlier appointment order in place.
Lordship.
In your case, their appointment order is not there.
Lordship, there are cases, Lordship, where Lordship, if initiation is given, Lordship, advertisement is given for certain post, Lordship. In that case also, Lordship.
Yes. As a lower in order of merit were appointed. They approach this. The persons lower in merit were given appointment earlier. So that is a distinguishable feature, apparently. This judgment is not of any help to the petitioners.
Lordship.
What is the next judgment?
Lordship,
Let's see this. Sanjay Kumar.
Lordship, these are of our court, Lordship. Lordship, today I brought a different set, Lordship. The relevant part I had marked earlier, Lordship, that is not here, Lordship. So I could not point it just now, Lordship.
What
But
happened?
it was there, Lordship. Lordship, para 24, Lordship.
of Sanjay Kumar.
Lordship,
Ji, read.
as discussed above, the respondent authorities have not explained the delay of about 19 months, which had occurred from May 2003 to December 2004 for completion of the selection process and declaration of results. That effort, the appointment orders of the petitioners came to be finally issued on 12/7/2005. Such a delay which occurred during the selection process as well as the delay in issuing the appointment orders cannot be attributed to the petitioners in the absence of any explanation forthcoming from the respondent authorities.
Delhi High Court had rendered several judgments
Lordship,
allowing writ petitions where persons similarly situated. So that was the peculiar circumstance in that case. This is not a case of selection process being delayed as such. These are compassionate appointments. So many a times, what is the reason for delay? Let us see.
no reason, Lordship. We have approached the Honorable High Court, Lordship. The High Court's orders are also there. Lordship may come to the Honorable High Court's orders, Lordship.
Let's see the single bench order first.
Lordship.
So where is the selection, sir? Earlier, only applications were there.
No, Lordship.
There was no selection.
They were selected, Lordship.
No.
They
You're
were
wrong.
selected, Lordship. Selection.
Read para 4. And then para 5.
Which one?
The impure order only.
Lordship,
Order of the single bench.
Lordship.
This is something different. Yes.
To appreciate the facts involved in the instant proceedings, it would be seen that the father of the petition, Lordship, that line, that paragraph. Seeing that the father of the petitioners had expired on various dates ranging between 1982 to 2003. The petitioners thereupon on the basis of the scheme of compassionate employed by the government of Assam had filed applications seeking compassionate appointment, though the applications were initially forwarded by the district level committee in the case of the petitioners. But the state level committee for compassionate appointments did not take into consideration the cases of the petitioners for which the petitioners had approached this court by filing writ petitions. This court by an order dated 9/9/2008.
Writ petition was filed in 2008.
Lordship.
So there was no selection before that, sir.
No, Lordship, there was selection. I have placed the list, Lordship. Selection list. Selected list. I have
Let us
placed,
see.
Lordship.
Where is the select list? Then why were you required to approach the court? Where is the selection list? Let's see.
Lordship, from
126.
page 26, from 26 onwards, Lordship.
Yes,
I have
read.
placed, Lordship.
This is a recommendation, not a selection.
Lordship, in this process,
Candidate
Lordship,
selected and recommended.
Lordship,
So that's simply a shortlisting kind of thing.
appointment, Lordship, the district level committee selects the persons, Lordship.
Selects for recommendation.
Select.
So it's a recommendation, it's not a selection.
Lordship, what the SLC
Appointment
do-
on compassionate basis is never a right. So these judgments you are citing,
Lordship,
they are cases of selection after competing for the post.
Lordship.
This category is entirely different.
No, Lordship, what the SLC do, SLC just goes through the list whether they have been duly selected or not, Lordship.
No, there is no question. There is no question of a formality being done by the SLC. The SLC examines everything, eligibility, comparable hardship, whether the hardship is there or not genuinely. This is just a forwarding letter, nothing beyond that. It is not a selection, sir.
Lordship, in many cases, it has been so held by the apex court, Lordship, and Delhi High Court also, Lordship, that, Lordship, if these persons had, if there was an advertisement prior to the new pension scheme, even in those cases, Lordship,
If there was
an
a-
advertisement, Lordship, no selection was done. And they had applied, then also they had the right lordship.
Sorry, sir. That's absolutely unacceptable. Yes, yes, what do you say, Mr. Masud?
The selection of the petitioners, the selection of the petitioners on the compulsion ground had come up on 2008, my lord. It was not prior to the oncoming of the new pension scheme. So their recommendation by the DLC is only that they were found fit to be
Eligible.
they were eligible.
Eligible,
But
that's right.
otherwise, whether they could be accommodated or not, had all come up in 2008 only. That way, my lord, their appointments cannot be said to have
Retrospective, with reference to the date of recommendation, they cannot relate back. Yes.
date of
Lordship, I can
recommendation
place
is only
some
like finding
other
of who's
judgments also
eligible.
if lordship allows me some time, lordship.
Enough, Mr. Bhagwati. Thank you. There's nothing in your case. All right, dismissed.
Pass away.
Hearing is with हो गया. Part 2.